Bob, so let's move to a contractor that has a DFAR 7012 clause in the contract, but determines for a variety of reasons that it's okay to wait to implement 800-171, either because they perceive limited risk, or they feel CMMC is coming, or that nobody's checking. And so that's a prudent, in their judgment, conclusion. Is that a reasonable conclusion to draw?
No, it's a risky conclusion. Every government contract has a significant number of clauses that are incorporated by law or by regulation. And the 7012 clause is one of those. If you're a government contractor, you're familiar with the list of clauses that are incorporated by reference, as well as those that are included in full text. Typically, 7012 is in full text, but not in all cases. I would ask you, the audience, how many times you have looked at any of the required clauses and made a determination that you don't have to do it. Essentially, the argument that you can ignore 7012 suggests that you would be willing to knowingly decide not to comply with something that is a contract requirement. 7012 is known to companies when they bid. It's evident when they take a contract. It is in force today. CMMC is really beside the point of the present obligation to comply and the present risk that would accompany failure to comply. And those risks are not just compliance, and they're not just the exposure to breach of contract. If you have controlled unclassified information, you are in possession of information which the government has concluded that law or regulation require you to protect. And if you fail to protect them, the government will be injured. And there could be consequences in the contract and outside the contract if it were found that you willfully or even negligently neglected those responsibilities.